All right, good morning, everyone. I'm Congresswoman Val Hoyle. I represent the Central and South Coast of Oregon and Corvallis and Eugene. So go Ducks and go Beavers. Over the last year, we've all watched the increasing presence of ICE in our communities and the overly aggressive way they are going about doing their job. No one should live in fear simply for going to work, taking kids to school, or seeking medical care. I'm working as your representative to stand up against these policies from this administration. This includes demanding the administration not open or expand detention facilities in Oregon, specifically on the Oregon coast, co-sponsoring multiple bills that would require ICE to visibly identify themselves and prevent illegal arrest, co-sponsoring the Immigration Court Due Process Protection Act to prevent DHS from arresting immigrants who are showing up for routine court hearings and check-ins, and co-sponsoring the Restoring Access to Detainees Act to ensure immigrants taken into custody can contact their legal counsel and families. What's important to know is this: if you are on American soil, whether or not you're an immigrant, you have the right to due process under our Constitution, and anyone saying otherwise is just wrong. Now, today's presentation will be led by Kate Sinkins with the Zantello Law Group. Kate's an experienced immigration attorney who graduated from American University, Washington College of Law, and began her career clerking for the Baltimore Immigration Court through the Attorney General Honors Program. She's worked with faith-based nonprofits and multiple federal agencies, including the Department of Justice, Health and Human Services, and Homeland Security, and she now practices on the Oregon coast. Kate's fluent in Spanish and has already led 18 Know Your Rights trainings across Oregon this year. We're grateful to have her expertise with us today, and with that, I'll turn it over to you, Kate.
Thank you so much, Representative Hoyle. I am so honored to be here, and I love living on the Oregon coast. So before we get going, I'll just say that I have a duck, but I love Corvallis, so I'm very much a beaver at heart as well. So today we're going to be talking about the rights of non-citizens and some recent updates that have happened in the last 6 months. Immigration, as I'm sure all of you are aware, is changing rapidly. This administration is changing regulations and rules, and the amount of money that's coming into enforcement is also changing how people are detained. So that is where we'll start, and then we'll go through some newer topics at the end. As you said, I do practice in Lincoln City, Oregon. We have had some detentions here, but we have had a lot of community members who also are really standing up for different community members here. ICE courthouse arrests are happening more and more at the Portland Immigration Court. There are arrests of immigrants without a criminal record. We've been watching what happened with Kilmar Abrego Garcia, who was deported and then brought back to the United States. And right now, birthright citizenship is being argued at the Supreme Court in this term. And then I'll talk a little bit about denaturalization and the Alien Enemies Act. So to start, our U.S. Constitution gives everyone living in the United States certain rights, regardless of their immigration status. This is the 14th Amendment. Gives people the right to due process of law and equal protection under the law. It's important for immigrants to know they have rights because the current administration has a goal of detaining 3,000 people per day, and they're getting very close to meeting their goal. We're also seeing that ICE will question and detain any person inside a home or an apartment, even if their name is not on a warrant. People who fall into this category are usually family members or friends, but they're referred to as collateral damage. Even if ICE is not coming to the residence to pick them up, if they are in the residence and the person opens the door, they will be questioned. It's really important not to sign any document without legal advice. What we're seeing in the Pacific Northwest is that an ICE officer will often put a document in front of a detained client and tell them if they sign it, they may be released from detention sooner. This is not always true. Any immigrant should not sign a document unless they're in his or her native language. The reason is that sometimes the documents say, I agree to expedited removal and I will get on a plane to be deported in the next 24 hours. Signing certain documents presented by ICE can lead a person to agree to leave the United States before seeing an immigration judge when they really don't understand what they're signing and what they're agreeing to. So if ICE knocks on your door, what are your rights? You have the right to remain silent. You have the right to inspect any warrant that an ICE officer presents without opening your door. You can refuse to talk to an ICE officer, and you can refuse to sign any documents before speaking with an attorney. There is no federal law or Oregon law that requires people to identify themselves to law enforcement. So the red card was created to exercise your right to remain silent and to refuse to let an ICE officer enter your home without a judicial warrant. I have a copy of it on the slide. It basically says, I don't wish to talk to you, answer any questions, or sign any documents. I don't give you permission to enter my home or speak to anyone here. It was created by a group called the Immigrant Legal Resource Center, which is out of California, and they started creating these cards over 10 years ago. They're now in 17 different languages. And if you are a member of a church or Girl Scouts or part of a service club in your town and you want to give them out to people in your organization, you can reach out to the Immigrant Legal Resource Center and they will send them with English on one side and whatever language you like on the next. This is a warrant, and there are two different kinds of warrants. There are judicial warrants and there are administrative warrants. We're starting with the judicial warrant. It is going to contain the name of a district court. It is going to be signed by a district court judge, and the immigrant's name and their residence address must be correct. If ICE comes to your door and the warrant they show you through the keyhole or through the window, or if they slide it underneath your door, has all of this information, it is in fact a valid judicial warrant and you must open the door. Again, at the top, it'll say United States District Court. It'll be signed by a judge at the bottom with a current date, and it should have the correct name and address of the person they are seeking. This is an administrative warrant. It's going to say U.S. Department of Homeland Security and a warrant of removal. It is signed by an immigration officer. Often it is not dated. Often there's no name or address on it. This is your cue or your key to realize this is not a valid warrant. It doesn't have any of your personal information on it, and it's not signed by a judge. If you see this kind of warrant, you do not have to open your door and you do not have to even speak to the person who's putting up the warrant so you can see it. It is an administrative warrant, not a judicial warrant, and can be ignored. So families should carry proof of immigration status at all times. Every adult and every child in the family should take a photo of their immigration documents and of their U.S. passport and save that photo on their phone. In the last 3 weeks or so, we have seen people who are getting pulled over who are U.S. citizens, but ICE does not believe them, and they are being detained sometimes for an hour, sometimes overnight. If you have a copy of your immigration documents showing that you have applied for asylum or you have been granted asylum, you have a green card, or you have a passport that's a U.S. passport, it's important to be able to show that to any officer of ICE or the FBI, the DEA, the federal marshals that comes so you can prove your status. Because if you can't prove your status, you are going to sit in a jail or detention center longer. So there are some recent updates which I would like to talk about. A lot of people have been noticing that there's many things that they're seeing on the news that are disturbing. It is getting more violent. It is happening on a regular basis. Maybe 6 months ago, we were seeing a couple of arrests, a couple of raids. It is a daily occurrence now, and we're seeing that cities are also targeted. So it started with Los Angeles, and then it went to Chicago, and it's gone to Portland and Minneapolis. Now it's New Orleans. And this is something that even if you're not in one of the cities that have been targeted, you should be ready for it because ICE has been given a lot more money this year, and they are going to be starting to arrest people and try and remove them via expedited removal as fast as they can. So Oregon has a Sanctuary Promise Act, and it prohibits state and local law enforcement or public agencies from participating directly or indirectly in immigration enforcement without a judicial warrant. It also prohibits civil immigration enforcement in a regular courthouse absent a judicial warrant. However, this president has decided that ICE can operate in any public space, including courthouses. So when you go to your immigration hearing or you go to an interview at the United States Citizenship and Immigration Services, sometimes there are ICE officers hanging around, and we have had people who have been detained in the last month in Portland. That doesn't mean it's necessarily going to happen to you, but I'm trying to let you know what's happening generally so you can be aware and take precaution. How to mitigate the risks of an ICE courthouse arrest. First of all, if you don't have to go to court, please don't go. You can ask the judge to appear remotely by seeking a waiver of appearance. You can also have your clients wait in a courtroom instead of the hall. One of the things we've seen is that people go into immigration court and there's only a certain number of seats. And so the other people who are not being dealt with at that time by the immigration judge wait in the hall, and then ICE can come down the hall and detain people. So if you can get in the courtroom itself, that's a safer place. Just a warning, ICE agents generally dress in plain clothes for courthouse arrests. If you suspect someone's an ICE agent, ask them outright. You can ask them for their name and their agency, their title or their badge, driver's license. They may not show it to you, but you can ask them what they're doing in a way that is non-confrontational. You're not going to push them, you're not going to shove them, you're not going to start yelling at them, but you are allowed to ask who they are. It's important to advise somebody, but not to obstruct. So if ICE is present, as an attorney, I'm going to tell my client that ICE is present, and I'm going to advise them they have the right to remain silent. I'm also going to advise them that they're free to leave unless ICE says they are currently being detained. I'm going to alert the immigration judge of ICE's presence, and I'm going to observe and take notes and take videos. When I talk about not obstructing an ICE officer, it's very important not to touch them. Even a hand on the shoulder like this could be seen as an assault. People are being charged with assaulting officers. However, you can put your body in between the officer and the person who is being detained. Just standing in between is not obstructing. It's not assault. So federal criminal law does prohibit concealing, harboring, or shielding an undocumented immigrant from authorities. But if you're just standing there, you're allowed to do that. That is something that is allowed and is something that we can do as fellow citizens to help the people around us. The Lake and Riley Act is something that President Trump has talked about it a lot. It applies to non-citizens who are admissible because they've entered the United States without inspection, or they were admitted, but they were admitted because they fraudulently used somebody else's name, or they were admitted without the proper documentation. Maybe they had a tourist visa, but they were coming in to stay. If that person also has been arrested or charged, convicted of, or admits having committed a burglary, theft, larceny, shoplifting, or assault of a law enforcement officer, that person is now going to be inadmissible. So it does apply to people who have committed crimes, but it does not apply to non-citizens who are admitted properly, people who were lawful permanent residents or refugees or people who entered on a temporary visa like a student visa. Next, we're going to talk about expanded expedited removal. This is a form of deportation that has been around for a while, but this particular administration has changed it a little bit. Expedited removal allows a DHS officer to deport a non-citizen without seeing an immigration judge. Previously, it only applied to people who were arrested within 100 miles of the US border who had been present in the United States for less than 14 days. Starting in January of this year, many non-citizens are subject to this unless they can prove physical presence in the United States for at least 2 years. That means keep your electric bill, keep your gas bill, keep proof that you're paying for your house mortgage or your rental for your apartment. Keep doctor bills and dentist bills. It's proof that you are in the United States. And if you can prove you've been here for more than 2 years, you are not able to be deported through expedited removal. So it applies to 3 groups: people who entered without permission, people who entered through misrepresentation, and people who entered without proper documentation. How to protect yourselves. Again, if you're a non-citizen, but you have a green card, always carry your green card with you. Have a copy of it at home in case you lose it. There's proof that you had it. For those who are in the US without permission, I would carry proof of that 2 years of physical presence, whether it's a gas bill, an electric bill, your mortgage, and a valid driver's license, as well as anything that you can prove you've been here. If you're a student, showing grades from a year ago, we'll do it as well. You always want to keep copies of this at home in case ICE takes these documents and does not give them back. Carrying it does cause a risk, because if you're showing someone that you're in the United States and you don't have status that's like a green card, they may say what country you are from, and that opens a whole nother line of questioning about where you're from, when you entered, how you entered. But it is important to show that you have been here for more than that 14 days and then again for more than 2 years. So I suggest people carry those documents. Currently, there is a bill pending in the House, HR 875, that talks about DUI. Getting a DUI in Oregon is considered a conviction for immigration purposes. It doesn't trigger grounds of deportation or inadmissibility, but it does make you removable. And so that's something to remember if you're in trouble with a criminal act. When you talk to your criminal attorney, make sure you know the repercussions of whatever you plead to on your immigration case. So if I could plead down to something less than a DUI, maybe driving without a license or reckless driving, that would have a different consequence according to my immigration status than pleading guilty to a DUI in Oregon. Like a lot of drug crimes, there isn't any waivers for inadmissibility. And right now, the bill hasn't passed. They're talking about having it apply retroactively. So if you were convicted of a DUI 5 years ago, it may still affect you if this bill passes both in the House and in the Senate. So next, we're going to talk about birthright citizenship. The Supreme Court heard oral argument on May 15th, 2025. The court has agreed to hear it because this current president believes that the 14th Amendment is something that can be negotiated. Now I'm going to read the plain language of the law so people just know what it says. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Once this was made a constitutional amendment, there was a case that came after it in 1898, United States versus Wong Kim Ark, And it was basically establishing that even though he had Chinese parents, he was born in the United States. And that's what birthright citizenship means. Even if your parents are in the United States without documentation or without status, if you are born in the United States, you are a US citizen. Congress did codify this in 1940 and 1952. So moving on, the question that was asked was, can a federal judge in a single district block the administration policy across the country? The current president argued that a district court judge should not be able to block his policies. And it's going through the court system now. I don't know how it'll come out, but there are a lot of people watching this case because it may mean that people who have always been able to get citizenship because they're born in the United States no longer will be able to. And what that looks like and how they'll be able to get a passport is something nobody can really answer at the moment. The justices asked, would children born in the United States to parents who are not US citizens become stateless, who are unable to get a passport or travel outside the US? They also asked, should the lower courts have limited rulings to the state, advocacy groups, and individuals who brought the case? That's something that we won't see until we see the decision, but it's going to affect a lot of people here in the United States. Denaturalization is something that we don't talk about a whole lot. It was used for the first time in 1906, but it's been brought up by the current president as a way to take people who have become citizens and find that they are no longer eligible for citizenship based on some fraud or some misrepresentation. So there are 4 reasons why US citizenship can be revoked. It can be revoked for illegal procurement or concealment or willful misrepresentation of a material fact. It can be revoked for refusing, under certain circumstances, to testify before a congressional committee on certain activities. This is what happened with the McCarthy era in the 50s. It can be, hold on one second. Sorry. Naturalization that is obtained through military service can be revoked if a citizen is subsequently discharged under dishonorable or any other than honorable conditions within 5 years of becoming a citizen. And if you procure or attempt to procure naturalization of anyone contrary to the law, meaning using someone else's information or using someone else's documents. So Operation Janus was originally started by President Obama. It was created to identify individuals who may have committed naturalization fraud. That administration consulted fingerprint records that were collected by USCIS for people who applied for different benefits, and it tried to figure out if people were using documents of someone else by comparing the fingerprints. President Trump has changed it to become Operation Second Look. Under his first administration, his Attorney General, Jeff Sessions, proposed reviewing 700,000 files of people who had become citizens. However, only about 100 of those cases were ever prosecuted, and less than 100 were found to be guilty. In 2019, Hoyle, the Office of Immigration Litigation in the Department of Justice, started an office that focused on denaturalization cases. 2 cases that are relevant to this are from 1967 and 1964. Schneider versus Rusk was a case where the Supreme Court said it's impermissible to assume that naturalized citizens as a class were less reliable. The argument being made was that people who were not citizens who were born in the United States may lie to the government and may lie when procuring benefits. That was voted down. And then in 1967, the Supreme Court determined that a naturalized American had not lost his US citizenship as a result of voting in an Israeli election. He was a dual citizen and was living part-time in Israel, part-time in the United States, and he was in Israel when elections were going on, and he voted. So a timeline to think about is that Supreme Court has held in April of 2025 that men being detained are entitled to notice and an opportunity to challenge their removal, but it has to be through a habeas corpus and it has to be in the district where they are detained. We saw this starting to happen with people. There was a Tufts University student who was taken from Massachusetts and put in Louisiana, and her attorneys filed a habeas corpus petition when she was in Louisiana, but the Supreme Court held that they needed to have filed it in Massachusetts before she was moved. Another case just a little bit later found that notice must be given within a reasonable time so the person can actually seek habeas relief before they're deported. And a reasonable time has not been defined by the Supreme Court, but it is more than 48 hours. That was part of the decision. This is just the history of those cases that are going on. There are a lot of cases that are in front of the court because of the Alien Enemies Act of 1798. It was a wartime authority that could only be used when the United States is under attack or invasion. It's been used 3 times: the War of 1812, World War I, and World War II. President Trump invoked it on March 15th, 2025 against Venezuelan citizens 14 years of age or older who are living in the United States, who the United States government believes are members of a gang called Tren de Aragua. We've seen a lot of different things that have been happening against Venezuela. There have been boats that are moving from Venezuela to the United States that the United States has said were carrying drugs, and people in those boats have been killed. There are lots of people who are in the United States with temporary protected status from Venezuela who are now been deported because President Reagan took away temporary protected status for a lot of different countries. What's most important, I think, for the average person is to know what your status is and to carry proof of it. And that includes US citizens. I carry my passport. I wish I didn't have to. I have my kids carry their passport. I wish they didn't have to. But we're doing it because there are US citizens who are being detained, and until they can prove that they're not in the United States without documentation, they're not being let go. So coming to the end of my presentation, I want to talk about one other issue, which is that you have the right not to open your door. You have the right not to respond if someone asks you about where you're from or what language you speak. You have the right to leave a situation where you are not currently being detained. So if somebody pulls you over and they say that they want to see your license and registration, you can say, "Are you a police officer?" And a state officer or a local police officer will say, "Yes, I work for the Lincoln City Police," or "I work for Lincoln County Sheriff," and they will have their name and their badge number on their uniform. If someone pulls you over and they're wearing camouflage, or they're wearing all black, they don't have any ID, any badge, any number on them, you have every right to say, "What organization do you represent?" And if they refuse to answer, I would lock your door and sit in the car. If you can leave without hitting anyone, I would leave. What we're seeing is when people don't answer, these ICE officers or members of the DEA or the FBI, a lot of times their windshields are being broken or the car window is being broken. That can cause more trauma to the people who are in the car than attempting to leave. It's everyone's decision what feels right in terms of safety at that time. But if you're in the car with another person and this happens, make sure they start filming it on their cell phone. It's really important to have evidence that things that are happening to you, so you can show someone later, whether that's an attorney or ICE or whoever you sue for that. So at this point, I'm going to open it up to questions from Representative Hoyle, but I want to say to you three things when you're looking for an attorney. You should ask your attorney, are you a member of the American Immigration Lawyers Association? If you are an immigration attorney and you are practicing, you should be a member. You want to ask them where they went to law school and where they graduated, and you want to ask them what state they're a member of the bar of. Many people are being scammed by people who say that they're attorneys, and they might be an attorney in a foreign country, but they're not an attorney in the United States and they haven't passed a bar exam in the United States. We recently had someone in Representative Hoyle's district who was scammed out of $5,500 by a person who held himself out to be an attorney, but he was not. $5,500 is a lot of money for any of our families, and that family is starting from scratch now, having to find somebody to represent their family member, having given a lot of money to somebody who is not an attorney. So ask them, are you a member of ALA? What law school did you go to and when did you graduate? And what bar are you a member of? If they are an attorney, they will have certificates on the wall that says what state they passed a bar in and what school they graduated from. So at this point, I'm going to turn it over to Representative Hoyle, and I thank you for the opportunity to speak.
So thank you, Kate. This is so important right now, and we've got people on all sides of the debate. Yes, we need comprehensive immigration reform. No, if somebody is violent, they should not be able to stay in the country. But that's not what we're talking about here. What we're talking about is the constitutional right to due process that this administration is telling through Homeland Security, their employees, that people in the United States do not deserve due process if they're immigrants, and that is wrong. So it is up to us to stand up to ensure that our neighbors are not targeted simply because of the color of their skin, and that Homeland Security doesn't decide to take away some of our life-saving equipment, like in Newport, in order to build a detention facility that is not adequate for the weather or for the place that they're trying to put it, specifically on the Oregon coast. I also want you to know that if you live in my district, that's Lincoln, Benton, Lane, Douglas, Coos, and Curry counties, that my team and I are here to help. We can help advocate for you at federal agencies, including ICE and the Department of Homeland Security. So if you need assistance, you can call my office at 202-225-6416 or visit hoyle.house.gov and click on How Can We Help at the top of the page, or help with a federal agency, and follow the step-by-step instructions. So with that, we will continue doing this. We will continue to do outreach in our communities. Kate, I want to thank you so much for giving us just the briefest outline of what people's rights are, because again, remember, whether you are a citizen or not, there are basic rights that are guaranteed to you by and through our Constitution. And with that, I'd like to thank everyone for joining us.
Thank you.